Thank you.
Christina, remember that case I was talking to you about yesterday with the client who keeps saying, well, non-cut client who keeps saying I'm his attorney and he wants a new date?
Yes.
Yes, he did it again this morning. Is it a Bronlick case?
Yeah, he was in. No.
Okay. I have not been retained. I just want to make that clear.
Kristen, do you recall his name?
Wallace.
Okay. Yeah, he was up here again this morning, so.
Okay, I made it clear to him. First off, I have not been retained. Number two, I'm not available for that March 6th hearing. I've already spoken to Christina about it, and said he intends to retain me, but he has not retained me. So I told him he needs to go to the hearing and say, I'm trying to get an attorney and I need a new date. That's what I told him to do. And instead, apparently, he keeps going to the courthouse saying, my attorney told me to get a new date.
Yeah, that's what, and I explained to him that's not what attorneys do. That's
Right.
not how we operate. So I explained to him as best as I could twice. He's been up here twice now, but.
So when we were made aware of it yesterday, because he called here after he did it, and Karen, my paralegal, was like, no, she's not your attorney, and so on and so forth. And then I was just forwarded a voicemail saying he did it again.
Yeah.
So I apologize. We are trying.
Yeah, that's okay. I just wanted to get it, clarified with you so, okay, well, thank you.
No problem. Sorry.
Court is now in session. Cyrus Surash versus Amber O'Connell.
For the record, this matter is before the court for review. Subsequent parties having engaged in mediation with Mr. Pratt for the front of the court this morning. This hearing is being conducted via Zoom. President is Attorney Kirsten Nemec, representing the plaintiff, Cyrus Surash. Mr. Surash is present. In addition, Attorney Hills is present, representing the defendant Amber O'Connell, and Ms. O'Connell is present. If the court recalls, one of the issues, primary issues, was parenting time. Is that correct? And any other issues? But in any event, who would like to place the agreement on the record that the parties have reached this morning?
I can do that, Your Honor.
Please, Ms. Nemec.
So the parties agree on joint legal and joint physical custody. Joint physical custody is for the purposes of making sure that Aurora is able to continue to attend, which is where she currently attends school and where the parties wish for her to continue to attend school. Parenting time, defendant's parenting time will be every other weekend from Friday at 6 p.m. until Monday, either to school or if there's no school, 11 a.m., as well as every Tuesday from 5:30 p.m. until school on Wednesday, or if there's no school, 11 a.m. The parties will exercise week on, week off parenting time in the summer and will utilize the Monroe County Front of the Court holiday schedule. There will continue to be a prohibition on Philip Reynolds ever being left alone with the minor child. Mr. Sorosh will be entitled to take tax exemptions related to Aurora every year. The parties agree to use Life 360 to monitor Aurora's whereabouts. Child support will remain as previously ordered in the amount of $436 per month, with Ms. O'Connell paying Mr. Sorosh that amount. The parties will continue to use AppClose with the provision that each party is responsible for responding to the other party within 48 hours. And finally, neither party will prevent Aurora from communicating with the other parent during their parenting time. And I believe that's the entirety of the agreement.
Wonderful. Thank you, Ms. Nemec. Ms. Hills, did Ms. Nemec accurately state your client's agreement?
Yes, Your Honor, with one clarification, which I probably should have mentioned when we were all in the room together. The week on, week off parenting time in the summer would be consistent with the terms that were in place for Mr. Sorosh, which was that when the schedule was his, he had the first full week of the summer. So it is my understanding that pursuant to that order flipping, that Ms. O'Connell would have the first full week of the summer, just to clarify who starts which week.
Okay. Do you agree with that, Cyrus? Is that how you guys were utilizing week on, week off?
Yeah, the way we utilized it was the first, like just continuing the every other weekend situation when it was my first weekend that started the week on, week off. So,
Okay.
yeah.
So I see Miss O'Connell nodding her head, so it sounds like you guys understand how that's gonna work and you can handle that.
Yeah.
Okay,
And if, Ms. Nemec, if you want to put language in the order which corresponds with that, with the weekend parenting time, the alternating weekend parenting time, I'm fine with that.
okay.
Wonderful. All right, so Ms. Nemec, if you want to wire dear Mr. Roche, please.
Cyrus, can you state your name for the record?
Cyrus Sarosh?
Okay. You heard the agreement that I placed on the record?
Yes.
Did you understand it?
Yes.
Do you have any questions about it?
Not at this time.
Have you had time to think about it?
Yes.
Have you had time to discuss it with me?
Yes.
Is anybody forcing you to enter into it?
No.
Okay. Do you believe that the agreement is in Aurora's best interests?
Yes.
Do you understand that you could have taken this matter to trial and the outcome could have been different?
Yes.
But rather than take this matter to trial, you're asking the court to adopt the agreement that I just read into the record and make it an order, correct?
Correct.
Are you satisfied with my representation?
Yes.
I have nothing further, Your Honor.
Thank you, Ms. Nemec. Ms. Hills, do you have any questions? First of all, for Mr. Sarosh?
No, Your Honor, thank you.
Okay, questions for Ms. O'Connell, please.
Yes, Ms. O'Connell, would you state your full name for the record, please?
Amber O'Connell.
Have you also heard the agreement which was placed on the record?
I have.
Do you understand all of its terms?
I do.
Have you had enough time to think about all of these issues?
I have.
And do you have any questions about it as you sit there right now?
Not at this time.
At this point in time, do you believe that this agreement is in Aurora's best interest?
I do.
Is anyone forcing you or coercing you into entering into this agreement?
No.
You understand that you could have filed a motion to modify the custody and or the parenting time?
I do.
By entering into this agreement, you're foregoing filing any such motion at this time, correct?
Yes, ma'am.
You understand that if you'd filed a motion, we could have had a trial in front of the judge, presented all the evidence in the case to the judge and let him make the decisions about custody and parenting time.
Yes, ma'am.
And by entering into this agreement, you're also waiving any right to a trial.
Yes, ma'am.
All right. Are you satisfied with my services on your behalf?
I am.
Thank you. I have no further questions.
Thank you, Ms. Hills. Ms. Nemec, do you have any questions of Ms. O'Connell?
I don't, thanks.
Is there still a matter pending in Lucas County?
No, Your Honor.
No, it's
No.
been closed.
All right. Okay, wonderful. Further, the court would like to thank and acknowledge Ms. LaPrade for helping facilitate and for resolution, of course, as well as Attorneys Nemec and Hills. The court would applaud you, Mr. Sarosh, and Ms. O'Connell, for reaching your own agreement. You know what's best for Aurora, better than anyone in this world. And the court applauds you for reaching this agreement. Obviously, there may be issues down the road, but those can be effectively addressed through effective communication. So please keep that in mind for best interests. The court, based on the agreement, parties, the court will adopt that agreement. The court finds it to be in the best interest of my child. It's a good job. Thank you again, Ms. Nemec, and Ms. Hills. You'll prepare the order, Ms. Nemec?
Yes.
All right, thank you very much. All right, that will conclude this. You can all zoom out and have a good rest of the day.
Thank
The record of this matter is before the court for a pretrial conference subsequent to the parties having engaged in mediation with Mr. Walker from the front of the court this afternoon. This pretrial conference is being conducted via Zoom. Present is Attorney Emma Green, representing the plaintiff Samuel Mills. Good afternoon, Ms. Green.
Good afternoon, Your Honor.
Mr. Mills is present. In addition, the defendant Stephanie. You are Stephanie Mills, is that correct, ma'am?
Yes, I am.
All right, good afternoon. The court has been informed that the parties have reached their own agreements. Is that correct, Ms. Green?
Correct, Your Honor.
All right. Ms. Mills, just want to make sure before we proceed any further that you understand that even though Ms. Green and or Mr. Reed from their office will prepare what's called a judgment of divorce, reducing to writing this agreement, their office represents your husband, Samuel, so their loyalties lie with Samuel. Do you understand that?
Yes, I understand.
But is it correct that you've reached an agreement this afternoon?
Yes.
Have you done so freely and voluntarily?
Yes.
And do you understand if the court adopts that agreement, there will be no trial in this matter? It's just a matter of reducing the terms of this agreement into a judgment of divorce. Do you understand that?
Yes, I do.
Do you have any questions before we begin?
No, not right now.
And lastly, you've had the opportunity to consult with an attorney if you chose to do so. Is that correct?
Yes, I did.
All right. The court's going to have Ms. Green state on the record what she understands to be your agreement. So listen carefully. After she concludes, I will turn to you and ask you whether that's a correct statement of your agreement. Okay?
Right. Yes.
All right, Ms. Green, could you please state what you understand to be the parties' agreement?
Yes, Your Honor, there is a spreadsheet. Both parties have had access to this and input to this. On my version, it's saved as the account details, domestic relation file. It is my understanding that the parties have agreed in terms of spousal support. Mr. Mills will pay Miss Mills $5,000 a month for a period of 10 years. In terms of the real property, Mr. Mills will be awarded those properties, and there's a family farm, and Miss Mills will be living on that. In terms of the financial accounts, again, the parties have a number of financial accounts on here, and they have divvied those accounts amongst themselves. There's also a joint account that is for their adult children for their tuition, and that's being held open for the children for that purpose. They have divided up their cars equally. There isn't any credit card debt, but they have also divided up those credit cards. In terms of the 401ks, the parties have agreed to an allocation, again, based on this spreadsheet. It's the plan to draft the settlement agreement so that both parties can review in detail to make sure that the wording, of course, is correct and accurate, reflects the spreadsheet. But the parties have agreed to the terms of this spreadsheet.
Of course, the court doesn't have access to that spreadsheet, but I think we need more specific in terms of what do you do about pension benefits? Will there be a qualified domestic relations order entered? Whose pensions will be divided?
Yes, it's a pretty substantial estate. There is a Fidelity account, a Transamerica account, and a Merrill account. Any quadros that are needed, we would probably suggest Mike Golomanis prepare those. Divide his fees equally.
Who paid the cost for the preparation of the quadros? They share that equally?
Yes, that would be equally divided.
Okay. How many quadros are expected?
I would probably try and minimize the number, to reduce the quadro fees. Right now, it looks like there's 3 that would be needed if it wasn't offset in any sort of way.
Okay. Ms. Mills, do you have a copy of this spreadsheet that Ms. Green has referred to?
Yes, I do.
Okay, and so you have that in front of you, and you worked through that as you mediated with Mr. Walker and reaching this agreement this afternoon. Is that correct?
Yes. Yes, I did. Yes, we did.
And you're comfortable that all the information contained there is accurate?
Yes, I am.
All right. With respect to spousal support, Ms. Green, when will that commence?
I guess we'd probably have it commence. I don't know if we want to do an even, March 1st, or if the parties want a chance to review the judgment, set it for April 1st. We didn't discuss it.
Will the spousal support begin on April 1st or March 1st?
It's agnostic. March 1st.
All right. Okay, that makes sense. March 1st then. And last, Ms. Green, is this spousal support, is it non-modifiable?
It is non-modifiable in duration and amount, yes.
Okay, all right. Personal property, the parties have been separated since October. The personal property has already been divided, correct?
Yes.
So each will keep the personal property currently in their possession. Spousal support, again, $5,000 a month for 10 years, non-modifiable, payable or commencing March 1st, 2024. How many parcels of real estate? Is there 2, Ms. Green?
There are 4, Your Honor.
4. All 4 parcels are awarded to Ms. Mills?
To Mr. Mills.
Mr. Mills, okay. So all the real estate, all 4 parcels are awarded to Mr. Mills. Any retirement plans and benefits will be divided. Are these pension or retirement benefits only of Mr. Mills? Does Ms. Mills have any retirement plans that will be divided?
No.
Okay, she's taking her no. So the pension benefits of Mr. Mills will be divided pursuant to the qualified domestic relations orders. And I'm sorry, there is no outstanding joint debt. Is that correct?
That's correct, Your Honor.
All right. Ms. Mills, did Attorney Green accurately state your settlement agreement? Ms. Mills?
Yes.
Did Attorney Green accurately state your settlement agreement?
Yes. Sorry, I thought you said Mr. Mills. Okay.
I'm
Yes.
sorry, Ms. Green. All right, can you, Mr. Mills, can you both please raise your right hand to be sworn? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
I do.
Thank you. All right, Mrs. Green, if you could begin with Mr. Mills to proceed with the proofs as well as confirm with him his understanding of this agreement, please.
Yes. Mr. Mills, at the time you signed your complaint for divorce, had Miss Mills been a resident of Michigan for 6 months and Monroe County for 10 days?
Yes.
And were all of the allegations in the complaint true at the time you signed it, and do they remain true today?
Yes, there are no allegations, I suppose. Yes.
Has there been a breakdown in your marital relationship to the extent that the bonds of matrimony have been destroyed and there remains no reasonable likelihood that your marriage can be preserved?
Possibly.
If the judge did not grant your divorce, would you be able to go back and live as husband and wife?
Possibly.
All right, so Mr. Mills, do you want to, we should maybe perhaps put this matter over. If you're not sure today, you want to proceed with the divorce, perhaps we need to continue this matter.
But that was our primary request going in, to arrange and understand the agreement. Our number one request, Your Honor, would be not to finalize today.
All right.
But we recognize there is a clock and we have to operate within that clock. But our request is not to put the agreement on record and know where we stand to move forward.
Okay, so Mr. Mills, you agree there may be there is a slight chance of reconciliation?
Yes.
All right, Mr. Green, of course, suggests let's proceed with the proofs. The court will reserve all outstanding issues. You got agreement upon the record. If in fact they can reconcile, that's wonderful. But perhaps at least that'll stop the court's time performance guideline clock by taking the proofs. The court will reserve all outstanding issues. And probably if we don't get a judgment, maybe in 3 or 4 months, we'll probably just send out another notice for pretrial just to, unless there's a dismissal that's been submitted. All right, so by taking the proofs, establishing jurisdiction has been a breakdown. There's no minor children. Mrs. Mills not pregnant. The court can reserve all outstanding issues, and that we don't need to then push toward a judgment divorce, Mr. Mills. So I'm sorry, Ms. Green. I don't know if you want to finish up. I think why don't you finish up with the proofs? I'm not sure where you.
Yeah, I will finish up with the proofs and then. Yep.
Okay. Please.
Okay. Mr. Mills, were there any children born or adopted to you and your spouse that remain minor children?
No.
To the best of your knowledge, is your spouse currently pregnant?
No.
And do you understand that you will be paying some spousal support to Miss Mills? And we're going to prepare a spousal support order, but after the amount and duration passes, spousal support to her will be forever barred?
Sorry, I don't understand that last sentence.
Yeah, so after 10 years and $5,000 a month, spousal support to her will be forever barred. After that time
Assuming that means it expires in 10 years, I fully understand.
Okay. And do you understand that you won't be receiving any spousal support?
I do.
Okay. And it's your understanding we're going to draft this judgment of divorce, allow you both an opportunity to review it, and pending that review, reach an agreement.
Correct.
And,
yes.
and by doing that, you understand that that'll waive your right to trial. You won't be able to come back after you reach an agreement and ask the judge for a trial where, you would have divided your property and it could have been the same, could have been worse, could have been better for you, but you're waiving that right.
I understand.
Okay.
Permission to ask a question?
Certainly.
I think I just said it's agnostic. It doesn't matter. March 1st sounds fine. That's tomorrow. I've actually already wired $5,000 to Stephanie independently because we do that every month anyway. But I don't know how I can comply with an order today for money tomorrow. And I obviously want to be in compliance. I assume that current process is acceptable.
Yes, and until there's a written order entered, you're not bound by it. So
okay, all right.
And if in fact, as long as you're current separate, as long as the needs of Miss Mills are being met, the two of you are on the same page, and no one's going to bring you back to court for not complying with this.
Understood. Thank you.
So obviously, if a couple months pass, there's issues, always reach out to Ms. Green or Mr. Reed for further direction or guidance.
Understood.
All right. All right. Anything further from Mr. Mills, Ms. Green?
No, Your Honor.
Thank you. Ms. Mills, did you hear the testimony of your husband, Samuel, this afternoon?
Yes, I did.
Was his testimony true and accurate to the best of your knowledge?
Yes.
Are you currently pregnant?
No.
Okay. Likewise, you've heard the conversation. You likewise agree to not push forward in terms of getting an actual judgment divorce entered, so you can
Yes.
explore reconciliation.
Yes, that was,
All right,
yes, that was our
wonderful. All right,
plan.
there's maybe in some counties there's some push to get judgments entered, but not in this county because court would much prefer the two of you fully explore reconciliation. You've been married 24 years. It's a long-term marriage, so it's worth exploring. Ms. Green, do you have any questions of Ms. Mills?
Ms. Mills, the only question I've got to ask you is, are you currently pregnant?
No,
That was asked and answered.
Okay, oh, sorry. Oh, I don't have any further questions then.
All right. So if in fact the parties decide to pursue the divorce judgment, you will then mail a copy to Ms. Mills for review and approval. Is that correct, Ms. Green?
Yes, that's correct.
All right. Okay. Very well. Based on the testimony that's been presented this afternoon, as well as the complaint filed this matter, the court finds that jurisdiction has been established and that there has been a breakdown of the marriage relationship. To the extent that the objects of matrimony may have been destroyed, it's unclear as to whether or not the reconciliation is possible. But at this point in time, the court will simply reserve all outstanding issues and not push for entry of judgment divorce until one is a consent judgment is submitted to the court. Again, Ms. Green, if in fact we don't hear anything, if there's not been a dismissal entered or a judgment entered, and perhaps in a couple months, we may send out another notice for pretrial just to see where things stand. But good luck to you, Mr. and Mrs. Mills, and exploring that reconciliation. Hopefully we can see a dismissal entered. Of course, any dismissal is without prejudice. You can always refile if need be.
Thank you, Your Honor.
Thank you.
All right, good luck both of you. That will conclude this matter. Thank you, Ms. Green. Have a good rest of the afternoon.
Thank you, Your Honor.
thank you.
Welcome. What do you, what's your time frame, Cindy, if we don't get a judgment in 3 months or something?